Imagine you are a traveler in 1852. You hire a courier for a months-long European tour set to begin on June 1st. But halfway through May, the courier sends you a letter explicitly canceling the arrangement. Historically, this put the traveler in a strange legal limbo. They could not technically sue for a broken contract until the actual June 1st start date arrived, forcing them to sit around waiting instead of hiring a replacement or mitigating their losses. To fix this exact problem, the courts recognized a legal doctrine known as anticipatory repudiation. This rule kicks in when one party to a contract clearly and explicitly announces they will not perform their obligations ahead of the scheduled deadline. Instead of waiting for the clock to run out, the victim can immediately terminate the agreement, stop their own preparations, and sue for a total breach right away. While this frees innocent parties from being held hostage by dead contracts, pulling that legal trigger too early carries massive financial risks. In the case of the 1852 courier, the court ruled the traveler did not have to wait until June and could legally take the courier to court immediately in May. But to claim this right, the breaching party's communication must meet a strict legal standard. It must be a definite and unequivocal manifestation of non-performance. In practice, this means the refusal to fulfill the contract must leave zero room for doubt, hope, or misinterpretation. As this legal text shows, the threatened failure must also constitute a material breach, meaning the cancellation would substantially impair the value of the entire contract, just like in the Hoxter case highlighted here. When the evidence of refusal is absolute and the impact is material, the law fully protects the innocent party's right to immediately pivot to a lawsuit. We can see the danger of overreacting in the 1963 case of Cohen v. Kranz, where a buyer attempted to back out of purchasing this mid-century suburban home right before the closing date. The buyer sent a letter demanding their deposit back, claiming the property structure was illegal because a split-rail fence projected too far forward and a swimming pool lacked a proper certificate of occupancy. The buyer made a fatal legal error. These specific property issues were minor, curable defects, not absolute or incurable failures of the property's title. Because the defects were easily fixable, the buyer was legally required to tender their own payment and give the sellers a reasonable amount of time past the scheduled closing date to fix the pool and the fence. By prematurely rejecting the deal without giving the sellers a chance to cure the defects, the court found the buyer's letter became the anticipatory repudiation. Consequently, the buyer lost their $4,000 deposit and was countersued for financial damages. Overreacting to minor, fixable problems flips the liability entirely, turning the person who thought they were the victim into the legally recognized breacher. We explore an even grayer area in the 1990 case of Drake v. Wickwire. Here, a lawyer advised his client to immediately cancel a land sale because the buyer's broker mentioned they were resisting the pressure to close. The phrase resisting pressure is merely an expression of reluctance. It completely fails the strict, definite, and unequivocal test required to prove the buyers were actually walking away from the deal. The Supreme Court of Alaska concluded that the lawyer was professionally negligent for treating this vague doubt as a definitive, actionable breach. The proper legal tool for these ambiguous situations is known as an adequate assurance of performance under the Uniform Commercial Code. When faced with reasonable grounds for insecurity, you can suspend contractual duties and demand written proof of performance. If the other side ignores the demand or fails to provide assurances within 30 days, the law converts their silence into a full repudiation. When faced with ambiguity, the law requires you to ask for clarity before acting, punishing those who destroy contracts based on mere suspicion. If you are facing a potential broken promise before the performance deadline, you hold 3 distinct legal options. If the refusal is absolute, you can choose to sue immediately, or you can ignore the threat for the time being and urge the other party to honor the agreement. If the threat is merely ambiguous, you can suspend your own duties and formally demand assurances of their intent. Keep in mind that a breaching party is allowed to take back their repudiation and reinstate the contract, provided the innocent party hasn't already canceled it. But they can only pull this reversal if the innocent party has not yet materially changed their position in reliance on the broken promise. Ultimately, the doctrine of anticipatory repudiation exists to keep commerce moving and prevent people from being held hostage by dead deals. As we saw with the buyers in Cohen and the lawyer in Drake, the law rewards clarity and punishes impatience. If you decide to sue early, you need to be absolutely certain the other side has already dropped the ball.